Hello and welcome to Tenant Law Basics. This is a series of short videos looking at landlord and tenant law in England and Wales in the UK. I'm Tessa Shepperson and today we're going to be looking at what is a tenancy. Now you may say, well, that's a bit obvious, isn't it? I mean, a tenancy is what you get when you move into a property and start paying rent. Well, to a certain extent that's right, but you don't always get a tenancy. Sometimes you will get what's called a residential licence, and then even if you do get a tenancy, not all tenancies are the same, and different tenancies have different rights. So if you want to know what your rights are as an occupier, you need to know whether you have a tenancy, and if so, what type. So in this video we're going to be talking about what a tenancy is, and the lawyer's answer to that is a tenancy is a legal interest in land. Now then, what does that mean? A legal interest in land it's sort of ownership. Land is different from anything else. It's unique. We've got a limited supply of it. We all have to use it to live on. Maybe in the future we'll have cities floating on the sea, but we haven't got them at the moment. Land's all we've got, and it's fundamental to our lives. Law has always treated land differently from anything else. I mean, it's often known to lawyers as real property as opposed to any other type of property. Now, the general rule is, which sort of comes from the Norman Conquest, is that all land is owned by the Crown. Now that's quite a useful rule because it means if there's a bit of land, we don't know who owns it, we know what to do with it. It reverts to the Crown, and the Crown owns everything, including the riverbeds and the shoreline. Now, if you have a legal interest in land, it's like held from the Crown. And it used to be very, very complicated. You know, over about 1,000 years, there's different types of ownership of land, suffrage and copyhold and all sorts of things. But this was all cut away and made a lot simpler in a very important act in land law, which is the Law of Property Act 1925. Now, the Law of Property Act changed everything and said that we only have two types of legal interest in land. The first one is called an estate in fee simple, and the second one is a term of years. Now what are they? An estate in fee simple is freehold land, and a term of years is leasehold. So freehold is the closest you can get in this country to owning land absolutely. You can own it for as long as you live, provided you don't sell it or have it taken away for you from a legal reason. You own, to the bottom of the earth to the skies, and you own it more or less absolutely, subject to the overall interest of the Crown. Now, a term of years is different. A term of years is created out of a freehold interest. So you can't have a leasehold interest unless you've got a freeholder sort of on top. A freeholder will grant someone a lease, and that will be granted out of their freehold interest, and it will normally be for a period of time. Basically there are two types of lease. There's long leases and there's short leases. Now short leases tend on the whole to be very short. They tend to be 6 months to a year. Leases, on the hand, long leases tend to be very long. They tend to be about 900 years. And so there's quite a big split. Legally, the main split is 7 years, because it's at 7 years that you need to register a lease with the land registry, and for a lease of less than 7 years you don't. So leases, all sorts of leases are in many ways very similar. They are created out of a freehold interest. The person has a term, they pay some sort of rent. So in that respect they are all very similar. However, they also differ in many ways. I mean, you have agricultural tenancies, you have residential tenancies, and you have commercial tenancies, which are all dealt with in different ways. In this series of videos we're going to be looking at residential leases, and we are going to be looking primarily at the short leases, which are normally up to about 3 years in length. Now, one of the problems that you get with short leases is that landlords often don't appreciate that what they are giving to their tenant is a legal interest in land, and that although the tenant doesn't own the land in the same way that they do, they haven't got a freehold interest, they do have a legal interest in the land, and to a certain extent they own it and control it during their tenancy. So that's all we're going to be talking about in this video. Thank you for watching.